thanks all for joining us. I know this is a little bit of a last minute, however, what truly seems to be a timely topic. So my name is Adam Hill. I am the president and CEO of Scarbrough Global. I'm a licensed broker, customs nerd at heart, really at the end of the day. On top of this, I have generously been given the opportunity to sit down here with Beau Jackson, partner at Husch Blackwell in international trade. So Beau, thanks for hanging out today.
Yeah, happy to be here, and apologies in advance for anybody who joined because they thought they might see the other Beau Jackson associated with Kansas City. If that was your expectation and now you see me on the screen, I'm sorry. I don't know if people had to pay, but I guess we should offer a refund.
No, this is free advice.
Free advice from a different Beau Jackson, not the one you might remember from Kansas City.
Are attorneys allowed to do free advice? I mean, that's another question, right? Like, do we have to, like, caveat this in any way?
It's called pro bono.
Okay, pro bono.
The only caveat I'll say, since you opened the door, is obviously this discussion or my commentary is my own perspectives and opinions, not speaking on behalf of Husch Blackwell, my law firm, or any clients of the firm. I do have a lot of clients in this area that I'm actively advising. Some of them may be listening in, who knows? So hope I don't say anything on this that is contradicted by something I've already told them. But no, happy to be here and just speaking in my own personal capacity.
Love it. So thanks again. Couple of just pointers before Beau and I just continue our conversation. This truly is just a conversation about a couple of trade nerds sitting down and really wanting to have a conversation and get you all as much information as truly as fast as we can. There is a Q&A section. If you have a question, please do ask in there. We will field them on the fly as they come in. We do not have a presentation for you. This is a on the fly conversation with what I hope you think are a couple of experts in the field. So I guess with that, Friday of last week, there was a bit of a decision made.
Yeah, that rocked my day. I remember leaving to go to the office that morning after taking some kids to school and telling my wife, I got a pretty light day. I don't have that many calls, no big, client meetings or anything like that. It's kind of looking forward to just a catch-up day.
Right.
And then, of course, I don't know, maybe around 10 or 11 in the morning, Central Time, the decision came out, and my day was thrown for a loop, and then the phone was ringing and the inbox was flowing.
Oh, yeah.
So, yeah, the Supreme Court, as I think everybody in this audience knows, finally came down with a big decision on IEEPA. Mm-hmm. And, yeah, happy to dig into the details.
I mean, if you think about it, so did you think it would ever happen? I mean, I think there's some press somewhere of me saying at some point the importers will win. Did you think that they would vote this way? I'm just curious.
I did.
Yeah, I did too.
It's easy to say that now.
So that's what I mean. Like, that's why I tried to I think there's some press somewhere of me saying I thought this was coming this way, but
I think I said it confidentially to a handful of clients, but then caveated with the usual, don't quote me on that.
Right.
I thought it would be 6-3 or 5-4 in favor of the importers. And then, of course, it turned out to be 6-3. And as I think most of the audience is probably aware, the decision concerned only the IEEPA tariffs. And that means the tariffs that President Trump imposed in a couple different batches, which we can talk about.
We got fentanyl, right?
Yeah, we've got fentanyl on China, imports from China, Canada, and Mexico. And then the Liberation Day tariffs last April on pretty much the rest of the world. And then finally, there were some tariffs on products from India and I think Brazil under IEEPA as well. And when we say IEEPA, just to make sure we're all on the same page, the statute is called the International Emergency Economic Powers Act. I guess kudos to the Trump administration for creativity. Didn't end up working in the end, of course, given Friday's decision, but this was a statute that no one really talked about anymore. Trade, economic lawyers, et cetera, we'd kind of forgotten about it, but they dusted it off and used that as the basis for a whole host of tariffs that we'll talk about.
Yeah, a little bit of chaos and madness, right? Like, and I always talk to our clients, like, whether you like our current president or don't like him, this is kind of outside of that conversation, right?
Yeah.
This whole idea whether you agree with tariffs, disagree with tariffs, just we've applied a lot, right? It started with the first Trump, with the first run of Section 301, which is the first time. I mean, I've been in this business 20 years now, and this is the first time that I've seen this much change. I mean, we historically had things like importer security filing, or we had, ACE is coming out, but yeah, they were changes, but not, I mean, these rocked people's world.
Yeah. And I could comment on that briefly just to set some historical foundation for us. For decades, there was kind of this consensus, for lack of a better word, of, free trade is good.
Yep.
And globalism is good. And, the United States kind of bought into that. China coming into the World Trade Organization in 2000 was obviously a monumental development in this regard. But then, when President Trump was campaigning the first time, back in 2015, 2016, he really made trade and tariffs a central pillar of his agenda, which no one had really done that for a while. And I think, and this is not to be partisan, it's just an observation, the parties kind of flipped in that regard.
They really did.
Democrats were kind of traditionally more pro-tariff or protectionist
Yep.
of U.S. manufacturing. Republicans were more the corporate party,
Yep.
Big companies importing and exporting, free movement of goods and people, et cetera. With Donald Trump, that all kind of flipped. And the Republicans in his first administration became a little bit more protectionist. So that was interesting. It was kind of the end of that, New World Order agreement. And there was discussion about, has international trade, quote unquote, free trade, been good for America, and in particular the working class, the Rust Belt, manufacturing companies, et cetera. And so you reference, Adam, the tariffs that President Trump imposed during his first term, Section 301, which we can talk about, largely on China, but those tariffs continue today. And we might see more use of 301, as we'll talk about. The Section 232 tariffs, which we'll discuss on steel and aluminum, and other sectoral tariffs, those still exist. So, President Biden during his 4 years really didn't disrupt the trade agenda that President Trump imposed in his first term.
Which let's take a step back and think for a minute. Like, our government likes money.
Yeah.
And it's hard to give it back. It's hard to give it back. So I think, fast forward to today, right? They are headed down a strange path.
Yeah. They hate to give it back. And, as our audience can probably appreciate, we probably have many importers worrying about their refunds right now. It's better not to ever give the money to the government in the first place,
right?
Than it is to give it to them and try to get it back.
Yeah.
And that's going to be the big quagmire now, is what's going to happen with the approximately $175 billion paid to the U.S. Treasury through IEEPA tariffs.
It's a big number.
Huge number.
Huge number. I pulled this morning, our small client base at the end of the day is $250 million in just IEEPA.
Yeah.
Just IEEPA. That doesn't include 232. That doesn't include 301. Just IEEPA. And what is now getting close to a full 12-month run. But I would say we're really not a full 12-month run until we hit April and we get the full Liberation Day.
Yep.
We did get a question just a second ago around what is IEEPA in covering? Is it reciprocals? Obviously, yes. It's both, right? We got the fentanyl plus, as you mentioned, Liberation Day.
That's right.
And I feel like Friday was really Liberation Day, let's be honest. Maybe I'll make some folks mad, but at the end of the day, I feel like Friday was actually Liberation Day.
Yeah, from the tariffs,
Yeah.
No doubt. Just a level set for everyone. The initial rationale for IEEPA tariffs was the fentanyl, and kind of also, illegal immigration. So Trump imposed that in March of 2025, about 6 weeks into his term, basically saying because there's a fentanyl trafficking problem causing a lot of deaths of Americans, and the immigration problem, primarily coming through Mexico. But fentanyl, of course, the precursor drugs, were manufactured almost exclusively in China. I never really understood why Canada was thrown in, but poor Canada. Maybe we could talk some hockey on this as well.
We should, because we keep winning gold.
We keep winning, yeah. No, that was amazing, men and
actually, the managing director of our Canadian operation is in the office today, so we rolled out a silver medal for him. Just to make sure.
I love it. Now, no disrespect to our Canadian friends, but go USA. Anyway, so it was, that was the original rationale. was let's use IEEPA to impose these tariffs on imports from Canada, Mexico, and China. And then really the big one was the Liberation Day, the Rose Garden ceremony, April 2025. Reciprocal tariffs, they charge us X, we're going to charge them X, et cetera. The Rose Garden ceremony with, the placards and everything.
Mm-hmm.
And that's really the bulk of what a lot of companies have been paying over the last 10 months. And but the rationale for the legal decision was the same. And I think this is interesting for any legal observers on this call. I wondered if perhaps the court might split the baby, might, instead of just slapping down all of the IEEPA tariffs, say the fentanyl and immigration issue was a quote emergency, and the president has the power to impose tariffs on the basis of that emergency. So we'll let those stand, which would have really been a big deal, of course, for imports from China. But for the rest of the world, for the quote unquote Liberation Day tariffs, there was no emergency. So we're going to strike those down. I thought that possibly could happen. It didn't, of course. Basically, it was the same rationale for all of the IEEPA tariffs, which was the statute as written. The text does not provide the authority for tariffs.
Right.
It does say the president can regulate importation. Notably, there's 16 words in between regulate and importation. So it's not like it was crystal clear.
I'm really good at the dot, 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 though.
Yeah.
Right? Like regulate, dot, 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 importation. Sounds great.
It's a creative thing.
Yeah.
Lawyers love to write that way to make something sound stronger than perhaps it is. I think the Supreme Court kind of thought that the government was making that point stronger than it was. But at the end of the day, 6 justices said, no, regulate importation does not mean you can impose whatever tariffs you want on any product from any country. And with that, the rationale was struck down and adios IEEPA tariffs.
I mean, at the end of the day, we are a country founded on the idea that you're innocent until proven guilty. And I feel like, and there's due process and things around. I mean, you talk 232, you talk 301, while you agree or disagree, different conversation, there is at least an idea of due process around it. And a stroke of a pen saying something that was on the water now has a 145% tariff from China just seems to be absurd.
Yeah.
In where we are today. And I think this is really going to get into some interesting conversations. So I don't know, maybe I don't even know what really direction to go here, right? There's 1,000 conversations to be had. I think the first one is the next piece of this puzzle is section 122. I've read a little about 122 here recently, and it was really never supposed to be used like it's being used. So I think there's some interesting potential legal lawsuits there running down that path. But I'm curious what you think. I think that while I think we have once again maybe stretched our authority, I don't think we're getting this money back. I think we're paying this for the next 150 days. I'm curious what you think.
You're talking 122.
Just 122. Let's
Sure.
talk about what's happening today. Happened as of 12:01 Eastern this morning.
You bet. And then we could circle back
And then
to
we'll circle back
pay
to
the refunds.
some refunds and stuff. But I think we want to talk about kind of where we are today and maybe set that groundwork.
You bet. So almost immediately, I think it was Friday night, within hours of the Supreme Court decision, the Trump administration said, okay, can't use IEEPA anymore. We're going to switch to Section 122. It's a portion of a different trade statute from decades ago that is basically written to address balance of payment issues. So IEEPA, international economic emergencies, has to be the underlying rationale for the action. Section 301, which we'll talk more about, unfair trade practices of a foreign government. Section 232, which we'll talk more about, actions from a foreign country that threaten our national security. That's the basis for any tariffs there. And then 122, which you're asking about, Adam, is actions, tariffs, or whatnot to address a balance of payment issue with a foreign country. The Trump administration has made some statements that, a trade imbalance, a trade deficit with another country meets that definition. I'm not so sure it does.
I'm not either.
And I think you're right to probably predict some litigation on whether tariffs, let's just say with Argentina or Spain or Portugal or South Africa, pick your country, whether Section 122 can lawfully address that if there's not a quote balance of payment issue with that country.
Right.
So I do think there will be some litigation on that, but in the meantime, that litigation almost certainly is not going to proceed quickly enough to have any effect on the short-term tariffs. So
No.
I think all importers can and should expect for the next couple months to be paying the new 10% tariff under Section 122.
Oh, and my gut really says, as this goes through, even if I don't feel like he's going to lose twice. So even if I don't know if we're going to be able to go back and potentially get money back. Now, maybe we can, depending on how the ruling comes down, if it ultimately goes. But I mean, someone's going to have to go to CIT, which we can talk about. It's going to get appealed.
Yeah.
It's going to make its way back to the Supreme Court. We saw how long that took. And this was insanely fast. I mean, if you want to, maybe if we just talk about that entire process, how fast this truly happened.
Yeah.
The Court of International Trade to a Supreme Court decision, I feel like this is like record time.
It is. And a lot of people probably don't feel that because their business has been on the line, has been dealing with this uncertainty, paying these tariffs. And so it probably feels like an eternity. And I empathize with that. But the truth is exactly what you say, Adam. It went all very fast from start to finish. The tariffs imposed last March and April, litigation at the Court of International Trade, a decision, I want to say in August or July or August, and then an appeal to the appellate court, Federal Circuit, which held oral argument, did the thing en banc, which meant all the judges participated. That was a split decision, interestingly, kind of like the Supreme Court. I think it was maybe 7-4, upholding the CIT. That was August or September. And then immediately to the Supreme Court, oral arguments were held, briefs were filed in October, November. Oral argument was held early December. And then a decision about 2.5 months later.
Insane.
So extraordinarily quick for our legal system to move that fast, especially in a situation of such magnitude.
Right. Well, and just crazy. So I think the big elephant in the room, I think there's a lot of fun commercial conversations to be had, but are we getting our money back, right? Like, I mean, the number of phone calls right now is how do I get my money back? And what I can tell you from an operator's point of view, today, Scarbrough has filed customs entries for our customers that do not have IEEPA duties on them. They were not rejected by customs and they were accepted as is. So to me, that's a win.
Yeah.
I had a really big concern that we had a Friday night decision and we had a Tuesday, this is happening. Could we keep up? Could the government technologically keep up?
Yeah.
Right? I mean,
To not demand the payment of those tariffs.
to not demand, or even though they have said today was the last day they were collecting them, could their system keep up?
And it has.
And it has, which to me was insanely impressive from the government standpoint to actually get this done, which means that as of today, we can file entries that don't have IEEPA. I have 122.
Yeah.
Different conversation, and we're going to get a lot of questions about that. But I mean, let's talk about refunds because that's the elephant in the room.
No doubt. No doubt. So, and I'm sure, people in this audience are hearing different things from different advisors.
Oh,
I
yeah.
can only tell you what we are generally telling our clients, which is you may indeed need to file a case at the U.S. Court of International Trade or the CIT to preserve your right to a refund. That's the prudent thing to do if you want to be sure, if you want to dot the I's and cross the T's. Prior to about 6 weeks ago, the thought was you might need to file protests with customs. But then there was an intervening decision from the CIT that basically said, no, this is not a ministerial matter before customs.
But it is.
It is now, but at that time it wasn't.
Yeah, but it is.
And so I think a lot of companies have been filing protests, which is fine. I don't think there's any downside to that. But I think it's pretty clear after the CIT decision that I'm referencing from about 5 or 6 weeks ago that if any action is required to preserve your right to a refund, it is likely through filing a complaint at the Court of International Trade. It's also possible, however, that the CIT is simply going to order the government to start processing refunds. I mean, customs has the data. You referenced, ACE and, systems. Customs knows who's paid which IEEPA tariffs on which entries. They could, if ordered by the CIT, just start processing refunds. I don't think that's going to happen. And if it does, I don't think it's going to happen anytime soon. As you referenced earlier, it's hard to get money back from the government. So ultimately, if I'm advising a company today that has a substantial amount of IEEPA duties on the table that they'd like to get back, my advice is generally go ahead and file a CIT complaint. It's just a relatively simple step. Law firms like us are doing that for a lot of clients, so you know you're in line. Because what you'd hate to have happen, God forbid, is the court ultimately says refunds for everybody who filed a case to contest their IEEPA tariffs. If you didn't file a case, you don't have jurisdiction to get your refunds. I don't think that's going to happen, but I wouldn't want, if I had, hundreds of thousands of dollars or more in IEEPA tariffs that I paid, I wouldn't want to get stiffed because I didn't take a small action.
That's why you're an attorney, I'm a broker, right?
That's
like,
right.
Like there's the argument of the day, and I have had this multiple times. You file a lawsuit, you file a protest. We advise our clients to file protests because in our mind, let's get past there is and you see this in customs all the time. There is the legal statute, and then there is the actual execution policy.
Mm-hmm.
And those two things do not always align. And oftentimes they don't. So if I think about customs from just an operational executional point of view, customs really doesn't have, while they have the data, they really don't have a mechanism to reliquidate an entry without a protest or a post-summary correction, right? Because I think there's also a line here around post-summary corrections, which we can talk about. But they really don't have the mechanism to do that outside of an order from a court that says, go do this. But even if that's the case, how do they actually do it?
Mm-hmm.
I'm not talking about no, you have to do it, because I think, in my opinion, the court saying, the Supreme Court saying, no, these are not legal, pushes the decision back down to CIT, right? And CIT gets to decide, hey, customs, hey, government, this is how we're going to do this next thing.
Yep.
And I guess quick sidetrack, are refunds real? Yes or no?
Real meaning, are they going to happen?
Yeah.
For IEEPA?
Yeah.
I think so.
I think so too. We get that question a lot. Oh, they're just not going to pay.
Yeah.
Well, I don't know how something can be deemed illegal and then say, oh, too bad, we messed up, but we're keeping it.
Yeah.
Like, that is ripe for more lawsuits and more litigation that ultimately the government will lose, in my opinion. So to me, refunds are real. It's not a question of if, it's when and how.
I
And I
agree.
think that's the question we're trying to argue over
Today.
is the when and how. One is, when do they come back? And then how do we go about that process? Because with protest, right now we're talking about, unfortunately, a human has to go look at it. There's no automated protest button clicker, as we said I know of today. So what does that look like?
Yeah.
And obviously, if you file suit, if you miss an entry, anything like that, there's no real log outside of the declaration. Whereas a protest, you're getting the electronic log per file almost.
Mm-hmm.
This 100 entries all been protested. But what are you protesting? Right? We're protesting a decision that is going to come from the Court of International Trade at some point in the future. And so you're right. To me, it's a very similar step to protecting your place in line, right? You've got AFR, you're forcing headquarter review.
Mm-hmm.
So I think this is where brokers and attorneys have differed from the get-go on this one topic.
Yeah.
Depending on who you talk to the most, do we file a lawsuit? Do we file a protest? Do we file both?
Or neither.
We have a lot of companies that have done both, where they're like, we don't know who's right. We don't really care who's right.
Yeah.
We just want our money back. And so we got them doing both. They're like, we're filing this and we're filing protests.
That's the ultimate, bootstrapping
right.
Approach. I don't think there's anything wrong with it. I think you just hit it on the head, though, Adam. If you're protesting, what decision by customs are you protesting?
You're protesting the liquidation.
Yeah.
Because customs liquidated an entry, and liquidation is a revenue mechanism, right? So we liquidated an entry based off of illegally collected tariffs. So therefore, you have a protestable decision. That's my book.
Yeah, I think there's an argument there. I think ultimately customs isn't going to do anything unless and until it's ordered to by the CIT.
I agree with that statement.
And so I think for those, watching for next steps, I think really the next action here is going to come from the CIT. I think it'll be, probably within the next couple of weeks, there will be, some sort of lead case designated in terms of IEEPA tariff refunds. There's already been about 2,000 CIT complaints filed.
Which is
on IEEPA, which is this many compared to how many could get filed. But, it's a big number and it's growing. And I think the Court of International Trade here pretty soon will issue some sort of guidance on what the process is going to look like. Let's hope. Going back for a second, a lot of people thought the Supreme Court was going to provide some guidance on this issue, and they didn't at all. And some even speculated that may have been why it was taking them. Again, it was a quick decision, but some thought it might be issued even quicker. Some thought that Chief Justice Roberts might have been trying to broker some sort of compromise, because he loves to do that, where, hey, we're going to strike down the IEEPA tariffs, but come up with a legal rationale not to allow refunds because it's just going to be too chaotic or too messy, as Justice Kavanaugh said. That's the one time it's referenced, is I think in the dissent from Justice Kavanaugh, saying the process is going to be a mess.
I agree.
But they were quiet. They didn't say anything. So the next step in terms of refunds is going to be ordered by the CIT.
So I think that there's a few questions coming in. I can answer one and you can answer the other one.
Okay.
The first one is, can Scarbrough file a CIT claim on our behalf? No, I cannot. I'm not a practicing attorney, nor am I a practicing, and certainly not admitted to
The bar.
the bar. So therefore, do I need legal representation to file with the CIT? I think yes would be the answer.
Yes and no. Great question. You can file it pro se, which basically means you file it in your own name. And you could, if you were able to get into the CIT docket and look at the samples of the other ones already filed, you could largely copy and paste and then fill in your own entry and importer of record information. Obviously, as a lawyer who practices in this area, my advice would be to engage a competent international trade attorney to do it for you. This is not an infomercial, but I could just say most firms, including us, are doing it on a relatively modest flat fee.
That's we've seen multiple firms.
Because it's not something that should be a huge legal expenditure.
Right.
It's kind of copy and paste and repeat, check some boxes, and make sure you do everything right to preserve the full ability for refunds on every possible entry. But technically, you can do it yourself. I would strongly advise getting competent counsel to do it on your behalf.
So this is a question I actually don't know the answer to. What is the statute of limitations on filing a complaint? I understand post-summary corrections, which I think we should talk about in a minute, protests, but what's that statute look like?
Yeah, it's one of two things, and there's some discussion on this in the international trade legal community. It is either 2 years after the executive order was announced. So, for example, if it's IEEPA tariffs for the fentanyl, the first batch, it would be, you have to file your CIT complaint in March of 2027.
Okay.
If
So
it's
you got a year still.
get another year still. If it's the second batch, if it's the rest of the IEEPA tariffs, right, the reciprocal liberation day, whatever, it would be 2 years after that executive order, which was April 2025, so April 2027.
Right.
Pragmatically speaking, I'd say do it much sooner. The other thing I've seen people write about is it could also be interpreted as 2 years after the date of entry or 2 years after the tariffs were paid. But the bottom line is you've got some time. But if I'm a company that's thinking about preserving my rights by going to the CIT, I'm doing it now. I'm doing it the next couple of weeks.
I'm sure just like you, I mean, we're the same way. The number, everyone's like, how do I get it back? Can you file protest? And that line's getting longer. And I hate to say it, but that line's getting longer. And while you may be able to copy and paste and get some stuff from the court, like filing a protest, filing a post-summary correction, there's work that needs to be done. It's like amending your tax return, right? It's not just, it's not a copy paste type scenario where you're just keying in a few points. So I think there is some interesting comments. There is a question up here. Someone asked that, they pay their duties to their customs broker, and then the broker pays the government. Where is that money flowing back? Well, I want to catch a couple of pieces of this. First, that money will flow back to the importer of record. This is also going to lead me to my FedEx conversation. I would love to have. That money flows back to the importer of record unless that importer has a form called a 4811 on file with the government, meaning that money flows back to the broker first. Most of you are going to say, no thanks, I will take my refunds directly. Quick, just public service announcement. February 6th of this year, the government stopped writing refund checks. to importers. It is a direct deposit mechanism only now, meaning that you need to have an ACE account and you need to have your banking information in there. And this is just, this is topic for another day, but I feel like this is just ripe for fraud. I mean, I hate to say that, but I feel like this whole idea is just ripe for fraud, but we can jump down that path.
By fraud, I don't disagree. Do you mean like hacking? And
no, but I mean, we see embezzlement cases, we see all that kind of stuff. And this, I mean, this is not small amounts of money.
yeah,
This is large amounts of money
yeah,
flowing back very quickly, potentially in large chunks.
good point.
And there is no check and balance in the system.
Mhm.
Like I am Scarborough's trade account owner. So for the entries where we do have 4811s on file, I had to go and put our bank account information in.
Mhm.
There's no check and balance. There's no government making sure that, oh, I put the right bank account number in, right? The only check in the system is that I put a 9-digit routing number in. It's the only check. So, I mean, the options of putting someone else's bank account, your own bank, I mean,
Yeah.
to me, that is just, that's scary
Yeah,
by itself. Because that's just an easy typo problem,
no doubt.
right? So you start to think about that. And then the other side of the coin is now they're doing it electronically.
Yeah.
We actually had a bunch of entries liquidate with refunds on February 6th. And I feel like we're in limbo. We haven't seen a check, but we also haven't seen a direct deposit. So I don't know if like what happening on that day, but that's just a general, this is an interesting run
No doubt.
of a few things.
I would just comment briefly on that.
Yeah.
Hopefully everybody on this call has a good customs broker such as Scarbrough. But this is the time when you really need one, because if you're in line for a potentially large amount of refunds, you want to have all your data at your fingertips. I've got some clients that, they didn't know how to log into ACE, it's just an example. Like, you got to be on top of that stuff. You've got to have your supply chain person or whoever have, a constant communication with your customs broker to make sure you understand and have the data at your fingertips. What have we imported over the last year? What countries? What IEEPA tariffs have we paid? What were the ports? What were the entry numbers, et cetera? Because you're going to have all that information to make sure you can confirm you get the refunds that you're entitled to.
So the other piece of this, I mean, we've started at the most extreme, file court case. Can I file? I'm actually curious. Can I file a court case if the entry hasn't liquidated yet?
Yes.
Okay.
Yeah.
So the minute I file an entry, in theory, I could add it. So how does that work on a go forward basis, right? So let's say for those people who have already filed a case, do they have to file a new one, or do they amend their filing?
That's an interesting question.
Because obviously entries keep coming, right? It's not like, oh, my entry's up through November. Well, I imported in December, therefore.
Right.
What does that look like?
So let's say, I think I understand your question. You file a CIT complaint today and list all the entries for which you paid IEEPA tariffs through December.
Right.
But you've got additional entries that you haven't yet paid the tariffs or whatever. But
because we hired you 2 months ago, you filed it 2 months ago, but now I've got this other new entry volume.
You could certainly file an amended complaint. There's no prohibition on that. You can amend your complaint at the CIT. It is kind of a pain, I mean, it's a good point, just pragmatically speaking.
Right.
The process can suck up some human time to deal with that, to make sure you preserve all of the possible entries for which you may want refunds.
Right. Let's talk timeline real quick. So you talked about 2 years for CIT. Let's talk about protests for a minute, just so we're all on the same page. You have 180 days from the time your entry liquidates to file a protest with customs. Like we talked about earlier, you can do protest and or lawsuit. You can do and lawsuit. I think that is going to be the mechanism for stuff that was done early on, March, April to May, right? But now we have this swath of work done. We'll call it the second half of last year into January and today. We are in an environment now where we are in what I would call post-summary correction hell, because we can now file a post-summary correction. And this is where I go on my protest comment. If I file a post-summary correction today, I remove those tariffs because they should not now be applied. That entry comes back. Well, customs was the one that approved that PSC. So why are they not the ones approving the protest? Like, how are those two things different?
Yeah. Good. That's a good question. So on a PSC, on a post-summary correction, my understanding is you haven't paid the tariffs.
You have paid.
You have
No,
paid,
so you've
but it
already
hasn't
paid.
liquidated.
It hasn't liquidated.
Yeah.
So we are making changes prior to liquidation, and customs prior to liquidating is now saying, okay, we are agreeing to the new number, right? You originally paid $20,000 in IEEPA tariffs. Now you're going to pay zero. They don't deny my post-summary correction. It liquidates. Now it liquidated appropriately.
Yeah. But are they giving you a refund check?
They would have to, if it liquidated for less, they have to give you the refund check. So if they're making that decision operationally today,
Why can't they make it on a protest?
why can't they make it on a protest? And this is where I think we run into this law and execution are off. And I mean, if anybody really ever digs into the customs regulations, prior to the Centers of Excellence, every single regulation in 19 CFR always ended with or at the discretion of the port director, right? Now we see or at the discretion of the center director, meaning there's all this law, but this guy over here or this gal over here can make the call on the fly.
Yep.
And so to me, we're trying to split hairs here on a legal argument, which I think there's valid points on both sides too. But it's just really interesting. It's like, no, you can do these now with no IEEPA tariffs because you are the collecting body, you are the police force here, but you can't approve the protest. It's just an argument that I have not really ever got my head wrapped around.
Yeah.
Why is it okay, but then it's all of a sudden not okay?
Yeah.
Like how you can't have both arguments.
I'll send and maybe you can put it out to this group somehow.
Yeah, I'd love to.
There's a CIT opinion that came out and
I've seen it about like the protest versus
yeah. It was in December or January, and that's what most lawyers are relying upon when they
Right.
say this is not a protestable action by customs.
Yep.
It's either a CIT complaint or you just sit back. And I guess if there's any small importers on the call, I would say if it were my company, and let's say I had 20,000 in IEEPA tariffs, I probably wouldn't spend the money on a protest or a CIT complaint. I would just sit back and hope that it's mandatory, that the court orders customs, just give all this money back.
Which I don't think they'll do.
I don't think they'll do,
Yeah.
but I'm saying if it's
Yeah.
only 20,000 in IEEPA tariffs,
Yeah.
is it worth spending 10,000 or whatever in legal fees plus,
Whatever.
human
yeah.
resource, consumption?
Yep.
Probably not. Now, obviously, if it's 100,000 in IEEPA tariffs,
Different conversation.
different conversation. So I would look at your liability here before making a decision.
I agree. And I mean, we've even had conversations because obviously we're charging to go back and file.
Yeah.
But we have customers who may be only getting $20 back on this because there's a certain item that maybe didn't qualify for USMCA or something like that.
Yeah.
And they're like, you're going to charge me more to get it back. And they're like, just don't file.
Right.
I think you are going to see some of that.
Yeah. Look at the cost benefit analysis for where your company's at.
So I don't know how, I'm not wholly read up on this quite yet, but I might as well throw it out and we can banter around a little bit. But we've seen all these trade deals, right?
Yeah.
Europe's trade deal come out with where we're capping at 15%. How does that play into IEEPA? Because if you start to think through this, like, is this a weird math problem where money comes out, but money has to go right back in? So it's actually, there's no change?
Yeah. Well, I know this was one of the things that the Trump administration was publicly most concerned about.
Oh, yeah.
Namely, Supreme Court, if you strike down IEEPA, you're cutting our legs out from under us in these international negotiations we're having with other countries. Of course, now that's kind of what's happened. But what's been interesting, and granted, it's only been 5 days, but other than Europe, I'm not aware of any other countries saying, hey, the deal's off, we want to scrap it, we want to renegotiate now that you can't charge us the IEEPA tariffs.
Right.
And I think that's probably part of the reason the Trump administration was so quick to come out with 122 last Friday, is they wanted to send a message to those trading partners. Hey, you may not have this 20% reciprocal tariff under IEEPA anymore, but you're still going to have this 10% tariff under Section 122. Right. The balance hasn't shifted that great, so let's keep our deal in place or keep negotiating, whatever. I think Europe will probably be the trickiest one.
I do too.
I think that one is going to be really complicated to play out. I will say, kind of bonus points for creativity, as I said earlier, on the Trump folks coming up with IEEPA. The conventional wisdom up until 18 months ago was, oh, trade deals have to be done on like a multilateral setting, right? You have the WTO, and
Yeah.
GATT, and yeah, you could have free trade agreements with countries one off, but in general, trade policy got set on a macro scale.
Mm-hmm.
And I think that's been proven false. It doesn't have to be that way.
Right.
We can have isolated deals and specific tariffs to specific countries if that's what we feel like. It was just the use of IEEPA
Mm-hmm.
that was found unlawful.
Right. Well, and I think that's always the argument, right? That there's an argument around, is a tariff good or bad? That's one argument, not for today. Whole different economic type conversation, right?
Yeah.
And then there is, why is this one wrong?
Yeah.
And it's not wrong because tariffs are right or wrong. Like, I don't want to get into that battle with anybody. It's wrong because we use power that wasn't given to us
Yeah.
to do.
Yeah.
And that's why it's wrong. And I think we have to kind of think through that.
One thing is certain, and this is more of a policy observation than a specific customs or legal point, but that is the U.S. market is the most important market in the world. Exporters from all around the rest of the world, most of them have to get products here.
And we buy a lot.
We buy a lot. We are a major consumption economy, a major manufacturing economy that relies on inputs from overseas. And I think there's power in that. And so tariffs, I think, were perhaps underutilized as a leverage point.
Mm-hmm.
The rest of the world wants access to the U.S. market, and tariffs are a way that we can get concessions on other things because they want access so badly.
Right. I agree. And so that's where you start to get into these interesting conversations.
Yeah.
I don't know if we have any foreign trade zone folks on the call, but if you remember early on in IEEPA world, there's multiple ways to get goods into a foreign trade zone. This could be a whole conversation for an hour just by itself. But in general, we had to file and put things into a foreign trade zone as privileged foreign status, meaning that we locked that duty rate in on the way in the door. Well, so now as the goods come out of the foreign trade zone, there is yet to be any comment on how we handle that problem because we locked in illegal tariffs 6 months ago, yesterday, right? A year ago. But now when they come out, what does that look like? Do we pay and get a refund? Do we not pay at all? And then if you don't pay it off, like, oh, we're just going to switch the status and give you the ability to go do non-privileged foreign. Well, now you have Section 122 on the back end to maybe catch some of that. So I think there's some really interesting conversations in the foreign trade zone world. I know it's a very small subset. I don't know if we have any foreign trade zone folks on here or not, but just something to kind of call out because I think there's some really interesting items and ideas around. We were trying to do one thing as a government, and I think we whiffed on the foreign trade zone piece of this anyways, and making people lock the privileged foreign status in. And now as we're coming out, we're going to run into some really weird things that I don't think anyone's thought through yet.
So is it possible, just playing this out,
Yeah.
that it's a simple subtraction? So let's say a product came in from Indonesia and the IEEPA rate was it 19%?
Yeah.
And that's what was paid coming into the FTZ.
Well, wasn't paid. That's the
Wasn't
weird part.
paid,
But it's locked.
but it's locked
Right.
at that 19%.
Right.
And then when it goes out, IEEPA's gone, so that goes away. But there's this 122,
Which is 10.
10. So is it going to be like, okay, 19 minus 10, and that's what you owe us? Is it going to be that simple?
I don't know. That's what's really interesting about this whole foreign trade zone piece is the way that works is when I file that entry, like if we talk about the execution of that, right? When I file that 06 entry type that says, oh, I'm pulling this out of the zone for consumption into the United States, I have to say it was this privileged status. And if the answer to that is yes, then the date, the tariff date on that entry goes backwards to when it was done.
Yeah.
So now the tariff date was before 122 existed.
Yeah.
So we can't charge me 122, but you also can't charge me this. So I think it's going to be, I'll be interested to see how this plays out. Because if they force foreign trade zone people to switch from privileged to non, that's a whole unique piece of legislation that's going to have to come out and say, no, forget what we tried to do. Now we're going to try to do this thing, which is right for things. So it's going to be a really, really interesting in the foreign trade zone.
Fun times.
Fun times. So,
and relatedly, I'll just comment on 122. The last I read yesterday was that duty drawback will be available,
which is huge.
So for anybody in this crowd who takes advantage of drawback, at least that's, a bit of good news in terms of next steps for your products.
It's massive, right? We have a drawback practice, and a lot of people have a drawback practice. So I think there's a lot that goes into that. Get a lot of questions around the ACE portal, ACE data. Does the data exist in ACE for you to get it out? Yes, that's the simple answer. It's all there. It's their unofficial profile of you as an importer, and it's free for you to get. So go get one.
Yeah.
Go get your account, get your refund information in there.
Know how to use ACE.
Yeah.
If you're importing. That's important.
Specifically, the ES-003 report is one of the best ones you can run. So ES as an entry summary -003. It's going to have every line item that was filed across every broker that you've used, even ones you maybe didn't realize you used. Because we see that happen from time to time as well. So we are getting some questions around the Section 122 stack on 232. Does it stack on 301?
My understanding is yes.
Mine too.
I have not read anything to the contrary, and I think in the absence of any definitive answer, I think we all have to assume yes.
I agree.
And that's a great question to jump into 301 and 232.
It is.
If you want to.
Please.
So we referenced at the start of this that, during Trump's first term, he used Section 301 in a novel way, almost exclusively on imports from China. We all remember that. And then the Biden administration kept those in place. He also used Section 232 to put the original steel and aluminum tariffs, which again were kept in place during the Biden administration, and then kind of expanded over the last year with the derivative tariffs. If you import a product that contains steel or aluminum, you've got to pay a 25% tariff on the value of the product that is the steel or the aluminum.
Right.
I'm sure everybody kind of understands that. So we have no reason to think that those are going to fall by the wayside. So for any products continuing to come into the U.S. market, you're going to have potentially Section 232, any existing Section 301 duties, and those have generally been upheld by the courts.
Yep, both 232 and 301 have been
Exactly.
upheld for the most part.
I saw something recently that the lawyers or the importers that were challenging 301 years ago and have lost are still maybe trying to take that to the Supreme Court. I'd be surprised if the Supreme Court takes that case. But I just throw that out because I read it. Anyway, yeah, I think those are going to remain in play. And the 122 10% tariff will be on top of those if those 232 or 301 apply to your products. But then I also think we're going to see new Section 301 investigations.
Unfortunately, I think we're going to see a lot of that.
Yeah. And the reason, most people probably know this, but the reason the Trump administration didn't want to use Section 301 this time is it's convoluted, right? There's a whole government regulatory process that they have to go through. They have to announce what the unfair trade practice is of the foreign country that they're trying to rectify or counteract. Then they have to allow 30 days or more for comments.
Yeah, there's public comment periods. There's
a hearing.
You mean due process?
There's a due process.
Oh,
yeah.
I'm
There's
imagining, right?
Yeah, there's a whole proceeding that occurs before any action can be taken under Section 301. But now that IEEPA is off the table, I'm not so sure the Trump administration is going to be satisfied with just the 10% under Section 122.
Right.
I think that we're going to see some creative uses of Section 301, which though would have to be targeted to imports from specific countries.
Yep.
Right, because we're targeting an alleged unfair act by that country. Or Section 232, national security tariffs, which you've seen on critical minerals, you've seen on steel and aluminum.
Still some due diligence goes into that.
But there is a process.
Yeah.
That's right. So if those types of commodities are important to your business, I would just say watch the news and engage in any regulatory process to make sure your views are known.
Right. We had, I think the other thing to call out around Section 122 is that they have already, if you go read, there's Annex 1, there's Annex 2. What I find interesting is we're already starting to carve out a lot.
Yeah.
So like aircraft has already specifically started to get called out. I just found the first one I glanced at was live animals, which made me laugh. I was like, great, I guess the cows come in a little cheaper. I'm not sure how that works. But so what I think was the other piece, though, is you talk about USMCA, you talk about that is already part of this conversation, right? And those items are getting excluded. We have, which to me is kind of an interesting piece around this as well. But it seems like we're already starting to maybe carve out the broad use. We're keeping USMCA allowed to reduce the tariff, which is great. We are keeping there, and now they're starting to be more and more and more carve outs, which I think is really interesting.
Yeah, I'm just looking at the list. Sorry, I'm shuffling notes around here, but the CMS notice that was issued looks like just last night on Section 122 does have a bunch of carve outs. I mean, tropical fruit, bread, pastry, cakes, essential oils, coconut water, live animals. So there's a lot in here that are carved out. I will say, though, it looks like I may have to slightly amend my answer on the 232. It looks like there might be a carve out
for 232
for derivative 232.
Gotcha.
So maybe not actual hunks of steel or aluminum, but the derivative 232 tariffs.
Which carves out, which historically there was under IEEPA too.
That's right.
Yeah,
you paid IEEPA, not those derivative tariffs, correct? So it looks like that may be
the other way.
The other way, and I think it'll be the same here. You will pay the derivative tariffs
and not
122.
22.
Yeah. So that
just now
devil's always in the
calling
detail.
NAFTA USMCA, and now I got to, I'm just getting done at IEEPA. Now I'm going to call IEEPA 122. I feel like half the time. I'll figure it out one of these days.
Yep.
But do a quick scroll here. There is a ton of questions coming in, so thank you all very much. Those of you who called it out, you are correct. But I think there is, like Beau said, there's a caveat to 232. And what I always like to tell the people who come to work here is when you're dealing with customs, you have to take your common sense hat off and put your customs hat on.
Yeah.
Because those two things are not always the same. And that's a tough one.
Yep.
For people, like the number of conversations I've had, people were like, well, this makes so much. I was like, I agree with you. They don't. I don't know why they don't, but they don't. And so I think, so we're getting close. We have about 5 minutes left here. But I think maybe we'll do a quick little recap. And then, so recap one, we do have avenues to file post-summary corrections, whether or not they will be agreed to or not, different conversation, right? We have avenues to file protests post-liquidation. We have avenues to file complaints to the Court of International Trade. So we have 3 avenues. Plus, I should say avenue 4 is an entry that was filed yesterday could technically be retransmitted today.
Yeah.
Right. So that starts to get a little interesting as well. On top of that, what do you think, though, crystal ball time? I like to end with the crystal ball. I would love if someone would like keep track of my crystal ball to see how good it's been.
I wouldn't.
Mine's very, very fuzzy at best, right? So what's the timeline? Like, let's play all this out. I mean, I thought the Supreme Court case was coming in June. It came in February. So, I mean, I was 4 months off already. So at this point, is that my best guess is that we might start seeing refunds somewhere between late Q2 and early Q3. That's my guess.
I think that's reasonable. I would agree with that. I would just say generally, I think Q3 is when we'll see genuine momentum on refunds being processed. But I think we'll know at some point in Q2 what that process is going to be. If it's going to be everyone has to file a CIT complaint or file protests, or there's just going to be an order from the court to customs to process it all. I think we'll know the answer to that in the next month and a half.
Yeah. By the end of the first quarter, I'm hoping we know the answer to that question.
By the end of the first quarter, I hope we know the answer to that question. And I'd say sometime, in the third quarter, at least, refunds are actively hitting importers' bank accounts. That'd be my not super confident prediction.
Hey, it's
lawyers don't like when
you guys don't like to predict
we
anything.
don't.
That's fair enough.
Yeah.
I just throw it out there and figure if it's right, it's right. If it's wrong, it's wrong, right? You got to take the shot.
I will say this though, if I'm advising the Trump administration, if I'm the USTR or whoever, I would, take my loss, agree to the refund process. Don't be difficult about it. Don't assign Department of Justice resources to gum it up and make importers go through all this stuff. because I don't really think that's politically smart. You've got alternative ways to do what you want to do, which is to keep tariffs on.
For a period of time.
For a period of time, at least 150 days.
You open the door here, right? You got 150 days.
Yeah. Through July
For
24th.
July 24th.
They got the 122 tariffs.
But that is also midterm season.
That's
So when you talk about politically smart,
Yeah.
I don't foresee anyone up for a seat saying, yes, let's keep them.
Yeah.
I think that's a tough, I don't care where your base is. I think that's a tough one to say, I voted yes for those.
That's an interesting comment. I don't disagree, although I will say, again, just Beau Jackson's personal observation, not legal advice, is I don't think the tariffs are as unpopular as maybe they were made out to be. I think they are, they didn't cause the inflation that some suspected they might.
I think it's coming.
Maybe it's coming. And I think for certain, manufacturing oriented parts of the country, they might even be popular if they're perceived as sort of reviving, moribund U.S. industries.
But is it like, if we look at the data, like the data doesn't really say that we're reviving much of anything.
I think Adam and I need to go have a beer and we could get into this and more.
We should, it'd be a lot of fun, right? But the other piece, and I know if you've got a couple of minutes, I could maybe have people kind of hang on for a minute, but is we talk about that. And the reason I say I don't think inflation's here yet is because we've talked to a ton of our clients over the course of the last year. And everybody we've talked to, and then I think there's one other piece I'd like to hit on before we call it a day here, is everybody we've talked to said, yeah, we haven't passed on the price increase yet. We're waiting until January 1st because they dealt with a big box store or someone who had 90 or 120 day notice period, which means that high pricing, while I think prices have been slowly climbing, I don't feel like that pricing, I think, is finally getting to a point now where those prices just got passed on. So you and I going to the store are just now starting to feel them. You look at that 6 to 9 month supply chain, it takes that long for these things to come into play. So I'm really curious.
Well said.
And so to me, that's the interesting part on this one with inflation. I just don't think we're there yet. I think people assumed, tariffs today mean inflation tomorrow. Well, I mean, our economy doesn't move that fast.
Good point. And I think we got onto this little diatribe, my apologies, because I was saying if I was advising the administration, I would take my lumps. I know 175 billion is a lot to give back.
Yeah.
But I wouldn't fight. I wouldn't make the process complicated. I would just let the refunds happen as quickly as possible and shift the focus to the new tariffs they want to impose.
I would agree.
I think it's a better battle to fight than fighting the refunds.
One other just general, I've got two other, I guess, pieces of just tidbit here. One, any of you who import, which is going to lead into my next one, that import parcels. This is an interesting one to me. If anyone paid attention to the Wall Street Journal last night, FedEx filed a lawsuit last night in the Court of International Trade. So technically a complaint, I believe, if my legalese is correct, asking for refunds where they were the importer of record. So everyone's going to scratch their heads for a minute and be like, well, they're not the importer. Actually, they are. So anybody that uses UPS, FedEx, DHL, United States Postal Service, that's an interesting one to me too. They act as the importer for those parcel shipments. We're talking about those individual packages coming in. You might be the ultimate consignee. And while FedEx paid that tariff, they were the importer. So they were the one that paid that tariff. They charged you for it though, right? Like Adam Hill on the bill saw more on my FedEx charge, but FedEx is the one getting the money back. I'm just curious where this goes. I brought this up back in our first conversation because no one was talking about this idea. You have this entire parcel network. Where's that money going? Are we getting ready to stuff the pockets of FedEx, UPS, and I hate to say the U.S. Postal Service? Think about it.
It sounds like potentially because they don't have any legal obligation to pass it on.
No.
That I'm aware of.
I don't have one either.
Yeah.
Which I think also brings into question customs in some instances. I have seen them historically look at, while yes, these were parcel shipments or FedEx acted as the importer, you as the ultimate consignee have some liability in this conversation. Well, then why would the money flow to them? So I think this is going to be an interesting conversation for any of those people who use FedEx to be going back to like, hey, knock, knock.
Yeah.
We just saw this. What does that look like? Or UPS. And just the other one, we've been having tons of conversations with our customer base on the commercial side of this. And I think a couple of questions have popped up, but who's giving money back, right? Like this is going to be the interesting thing. How many prices got passed on?
Yeah.
Oh, there's a new tariff price. Well, here's now the price used to be $100, now it's 115 because I'm paying 15% more. You start to look at that. I think there are going to be some really interesting commercial conversations in 2026 around what this looks like.
True.
Just from an individual, are we giving money back? Are we not giving money back? Are we sharing it with our customer? Or you have the people, and I don't know where you guys kind of fell in this. We had a lot of people who said, oh, I'm going to pass the burden of importing off to my shipper now.
Yeah.
Switching terms, we're going DDP.
Yeah.
They're going to take care of it. They're getting a way better deal than I could. And we can argue about why they got that better deal, but I think that becomes interesting too. Like, oh, wait, now they're the ones getting the money back, not me.
Yeah, I can comment on that briefly from a legal standpoint. I know in 2025, we helped a lot of clients on both ends of these. Importer clients passing a tariff surcharge
Yep.
or whatever it was called onto their customer.
Yep.
Well, those customers now, if they find out that the importer who supplied them got that back, do they have an argument to get it back?
Right.
Otherwise, it's a windfall for the importer.
Right.
And we also have clients who were the customers who we helped minimize the amount
Yeah.
of those tariff surcharges. Say, no, you can't stick that on us. Stick it on your foreign factory, whatever. But either way, there's going to be awkward commercial conversations, and just this is a macroeconomic issue that will start being discussed if and when refunds actually become a reality.
Absolutely. With that, I know we're past time. Beau, thank you very much for traversing up here.
This is great.
Yeah,
Enjoyed
absolutely.
it.
Thank you. Thank you all very much.